your partnership, Tom. It is invaluable to what we do here at the department. This has to be a partnership. It's not about the department merely enforcing requirements. It's about us working together to make sure we give the best possible experience to our students. And that is exactly what we are going to try to do right now.
Excellent.
And I believe that you're going to be able to see some slides on the screen.
I was going to say, I can see the screen.
That's progress.
Go two over. Go to the one that's just two more over from there, Jim. One more over.
There we go.
There you go.
Yeah. Okay. So after that little technical difficulty, we'll get going with the material that we have for today. And again, I appreciate everyone who has joined the call, and we are committed to doing more of these types of events to make sure that people have the information that they need to do the best job that they can. And one other thing I want to say before we get started is to remind all of you that if you have issues, questions, problems that arise, please feel free to reach out. We actually appreciate that. It's not the sort of thing that in the main results in program reviews or any kind of enforcement activity. Instead, it is how we get the best overall compliance, because it is simply not possible for us to enforce our way to higher levels of Clery Act compliance. There's not enough of us, and there are 11,000 campuses out there. Ultimately, what we need to do is help schools to do the best job they can and come to us for assistance, and then we will do the enforcement cases in those situations where people purposefully choose to not comply, which happens more often than you might think unless you watch the news. So we're going to talk about some compliance essentials, some best practices, and some lessons learned. Now, I want to start with a disclaimer. Some of the material that we have to cover in this area is, as you might imagine, graphic and violent. And it could be disturbing for some folks. So I want you to think of this as a warning, a friendly warning, and a reminder that if for any reason you need to, just take the slides down or walk away for a minute and come back to your computer, you can do that and rejoin the discussion. And in a setting like this, we have to keep the conversation at a fairly high level, because these rules, like a lot of Title IV rules, require all of you to develop and implement policy and procedure. You can't simply just read the rule and apply it to your institution without thinking about your unique circumstances. The Clery Act, if there's anything complicated about it, it is the fact that it essentially shows up differently at different kinds of institutions, and that kind of makes sense for a law that is keyed in on campus safety and crime prevention and has to apply to a small cosmetology school that may have 50 students and a mega state university that might have a daytime population over 100,000. So we always want you to feel free to come to us and with your unique issues, and we can help you apply the rules in the way that makes the most sense. Okay? I just also need to say that, this is a discussion for C-SPAN and its members, and what we would ask is that you not use the material that we talk about today in any kind of outside purpose. This is really for the benefit of members of the group. Okay, with that, we're going to go on to the basics of the Clery Act. Now, we talk about some of these issues quite a bit, and somebody might be saying, I've heard Moore talk about this before. Why is he still on these basic issues. And the real reason that we're on them is because, unfortunately, some institutions continue to violate in these areas. Most of the institutions on this call today are going to be relatively small, even if the companies that they're part of are much larger, but each individual school will probably have a smaller overall student body. I'd bet in the hundreds in most cases, but probably not the thousands. That does not have any bearing on the importance of the Clery Act, as we'll see as we go forward. In some instances, I will use examples mostly from bigger institutions to make points that actually apply to every school in our programs. And as I say, there are over 6,300 program participation agreements out there in those institutions. Those 6,300 schools are operating over 11,000 campuses. And of course, everybody who operates at least one campus has to comply with Clery, and the central requirement of the Clery Act, the most foundational requirement, is to have an annual security report. It is what it sounds like. It is a report about your campus safety and crime prevention program, and you might think that you don't have a very vast one. The schools on this call are not going to have their own police departments. They may not have one contract security guard, but you still have to have policies and procedures in the required area, and we're going to talk about what some of those areas are. You still have to have the ability to issue timely warnings and emergency notifications. You need to think about how you would evacuate your building if there was an emergency. I actually run across more career schools on a regular basis that have decided to get into the housing business to one extent or another. It might be the control of a couple of apartments or perhaps one house that the ownership group decides to purchase and rent rooms to a number of students. It can be an enrollment management feature. All of you know that schools will often pick the very location of a particular school because it's convenient to students, right? Perhaps it's on the bus line or it's right downtown where many people work. Well, many schools have decided, you know what, we have students who drop out of school from time to time simply because they have housing situations that become difficult, and so we're going to take on some housing. Well, obviously, becoming a landlord is a big legal deal. And in addition to wanting you to make sure you've talked about it with your attorneys, I also want to make sure that you consider Clery Act compliance in that mix. We won't spend a lot of time on it because relatively few schools will have that issue, but if you have housing at your school, it may be worth a follow-up discussion, and we can certainly arrange for that. And then we get into the other big-ticket item that we need to talk about today is the Violence Against Women Reauthorization Act of 2013, the so-called VAWA rules, which amended the Clery Act in important ways that apply to all schools. And it's during that discussion that we'll talk a little bit about Title IX. When Tom and I were thinking about doing this webinar, we thought that the new Title IX rules might be out by then. They have continued to be delayed as the group at the Office for Civil Rights works on perfecting those rules. As Tom mentioned, it was one of the biggest responses that we've ever had as an agency in terms of public comments. And as many of you know, every one of those public comments needs to be read and categorized and responded to through the Federal Register. And that is the work that they've been undertaking now for many months. And we need to touch on that because the rules will come out soon, and after they do, we may have to consider early in the new year having another webinar to help break down those new Title IX rules in ways that will help you make sure you can follow them at your schools. So we can never forget that participation in Title IV is a contractual arrangement. Everyone on this call is very much aware of the program participation agreement and the important role that it plays. It's important to remember in all areas of Title IV that that contract basically says that the institution understands its obligations and will live up to them. That's a pretty high standard. And failure to do so can have negative results. We don't want to focus on this piece, but we do need to talk about it for a minute. Many of you know that Congress several years ago essentially put fines for violations of Title IV and everything else in the federal government. All civil penalties are now on what you might think of as autopilot. They are adjusted at least annually based on the Consumer Price Index. That allows the fines to remain relevant without Congress having to take new action all the time. The agencies have to issue regulations. We have to issue notices in the Federal Register every year that say what the fine will be. It's already been determined that the fine will go up again sometime within the next 12 months to probably close to $60,000 per violation. As some of you know, institutions can be put on provisional certification or even subjected to heightened cash monitoring for failures to comply with the Clery Act. It was noticed by many observers that that was what was done by the department in Michigan State University. You might not typically think of an institution like that being put on heightened cash monitoring or having provisional approval, but in fact, they do now, and it will continue for a period of time. They were recently recertified on a provisional basis for a period of only 1 year. So you can see how serious the agency is taking this area of the law. And along those lines, even though we have to talk about things like reputational harm, I want to make sure that you all understand that as I reference names of institutions throughout this presentation, I'm not picking on anyone, or I'm not doing it to be negative about them, but they are settled cases. They are in the public domain, and they're situations that each of you can learn from and try to avoid the problems that those schools faced. Okay? We are just in an era of high competition in higher education. Each one of you knows that. It can be difficult to fill a class, and it can be difficult to keep it full once that particular group starts classes, because you're going to have withdrawals and you're going to have people in programs where it's possible reduce their course load. And all of that has an effect on the institution. I can tell you that the focus of the media on issues of campus safety is something that everyone has to be aware of. Students are increasingly focused on this area of the law. There was a time where students didn't care very much about the general topic of campus safety. Parents may have, but students didn't so much. They do now. And if they feel as though they were in some regard unsafe, they will take to Twitter or Facebook or whatever their other outlets are and possibly say things that could hurt your institution and hurt the business. So we want to think about this, for those of you who are in ownership or management, from a risk management and legal exposure standpoint as well. And those things can always pose an existential risk to our operation. That's true even for these public and private nonprofit schools as well. We've had schools that have had significant decreases in enrollment after they have one of these problems, or they have terrible budget issues after these kinds of crime violations are identified and become public, because people on their own, or as a result of their parents or their counselors' influence, say, I'm simply not going to go to that school. I have other choices, and all students have other choices. So we need to make sure that we give them the best information we can, we make sure it's accurate and complete, and we do what we can to keep them safe. This is a list of some of the major program reviews that the department has conducted over the last few years, and the year that's noted is the year that the case became final. There's something I want you to realize about this list. If you see a school like Georgetown, you see we've covered the elite private institution. We have community colleges on there, large mega state universities, small regional liberal arts colleges. But what I also want you to know is, as you go down that list and you hit schools from across the country of different types, You see there's even an HBCU in there, South Carolina State University. And then at the bottom, you see some of the higher profile cases of just this year. University of North Carolina, Berkeley, and of course the Michigan State case, which got quite a lot of public publicity and attention. But what I would encourage you to do is go to that website that is listed at the top of the slide. That is the website, we call it the data center, where eventually, at least over time, all of the Clery reports, whether it's an audit resolution case, a program review, or anything else that we're involved in, those documents are posted there so the public can see them and learn from them. You will notice that there are a lot of schools in the career area that now have been cited for Clery violations, usually during a program review conducted by one of our regional offices. It would be unlikely, quite frankly, for the Clery team to come out and do a focused campus crime program review at a school that has, let's say, 75 students that's in an office park somewhere. It could happen, but it's somewhat unlikely. However, it is entirely reasonable to expect that over a couple-year period that one of our regional teams would come out and do a program review at most schools. That would be the expectation of the agency, that certainly, say, every 5 or 10 years, you're going to have a program review, and now those program reviews will have a component that involves Clery testing. For schools that have any housing, there'll be some testing of compliance with the HEA fire safety requirements, and of course the Drug-Free Schools and Communities Act, which is a rule that every school has to comply with. I think there's still some confusion out there based on information I see all the time that would suggest that some folks don't realize that even the smaller schools or some of the schools where everybody goes home at night still have to comply with Drug-Free Schools and Communities Act requirements. So I mentioned about the annual security report. It has to be what it sounds like, a report, which means a front cover, a back cover, and all the required information in between. A lot of our schools in the career school space are continuing to struggle with this requirement. And sometimes it's because they think that because they've answered the department's annual crime statistics survey, they think that's all I have to do. I have to send my crime statistics to the government. Once I do that, they'll leave me alone. And sometimes they think if we take those statistics and we email them to all of our students and employees, we've met this annual security report requirement. That's not the case. There's 2 separate requirements. The first is to have an annual security report that has all of your policy and statistical information in it. And of course, you have to distribute that report to all of your enrolled students and current employees. And then there is a survey requirement. All schools that have been in the programs for a long enough period of time will get a packet every year advising them how to complete the survey. And so it's really 2 requirements with regard to crime statistics, not 1. Now, with this distribution requirement, I just want to say that it needs to be what we call active distribution. What's that mean? That means you can't just leave a pile of these reports sitting in your admissions office or around classrooms, and even if you put a note in your newsletter or however you communicate with students that says, well, the report's done. If you want one, pick one up on your way home next time. That's not how it works. You actually have to give it to the students and employees. If you do email, which of course many career schools do not, right? They don't set up an email account for every student who comes through for a certificate program. It's expensive and it's clumsy, and they choose not to do it. The big schools, of course, give students email addresses usually for the length of their enrollment or the time of their tenure of employment, and so it's easier for them to make some of these distributions. So this is the one area where I would argue that compliance might be a little more difficult for the schools in our space today than for the big schools. Overall, I would say in the Clery space, the bigger schools, the traditional institutions, probably actually have the harder time of it, which, as many of you know, is probably not the way most of us would see it with some of the other Title IV regulations. So the other piece I want to let you know about with distribution is the idea of notification of prospective students and employees. Here the requirement's a little bit different. You don't actually have to hand it to those people. Instead, you need to make them aware of the fact that the report is available and tell them how to obtain a copy if they want it. So some folks have taken to making this report available, or at least a notice about the availability of the report on whatever the application form is for the school. So, of course, a lot of schools have gone to online applications, both for enrollment and employment. You can make it so that a little bubble pops up, or some kind of little pop-up box or information window that says, if you're interested in campus crime information, click here. Okay, so if you had a program review and the reviewers asked, how do you meet the notification requirement? You take them over to the computer and bring up your web page application form and show them where that information is, and there shouldn't be any more question about it. Now, I'm not going to read all of these policy areas to you, but I will point out that the Clery family themselves, when they started to advocate in this area after their daughter Jean was killed in 1986 on the campus of Lehigh University, they were very keyed in on the idea of safety policy, not just the crime statistics. The crime statistics get a lot of the attention in the press. You know, if you have one of these situations where a school, for whatever reason, purposeful or by negligence, underreports crime on their campus. But the family that started all of this was very concerned about schools having campus safety plans and policy statements that would be made available to students and employees if they want them. Sometimes schools, small schools, big schools, will say, we don't think we should have to do all this. It doesn't really seem like most of our students are that concerned about it. I'll tell you when they get concerned, after something happens, right? And then all of a sudden they're very interested in what the school's policies are or were, and also their attorneys get very interested in what the policies and procedures were. So you want to make sure that you have them both as a preparatory matter, a proactive attempt to make the school as safe as it can be, and then almost as a shield. That's where we start thinking about risk management. Okay? And what we want to do is we want to highlight a couple of the policy areas. Timely warnings. You see this involving mostly the large residential schools, but any school could be the subject of a dangerous condition or a serious crime, and we'll get into more of that later. But you need to have a way to warn your students. That might mean you collect cell phone numbers for all your students and employees and you send them text messages as a group text, either using sophisticated software that now exists or perhaps no software at all. Maybe the executive director of the location has everybody's cell phone number and can text them and say, there's been an emergency. We do not want you to come to class tonight. We need you to stay clear of the area. We will be in touch as soon as class will resume. Or it might be in the morning students, the daytime students, that there's been a snowstorm, and you want to make sure that they know under our emergency notification policy that weather has caused us to close the school. We don't want the kids to risk life and limb to get there to find the door locked, right? We also have to think about how we would evacuate our school. Again, this is not just a big school problem, and I'm going to give you a couple of examples of cases where it went wrong. And we want to make sure that we have an understanding of what the overall safety program at the school is. Who are people supposed to report crimes to? Again, most of our schools are not going to have a full-time security officer. But in point of fact, the school is going to have at least one so-called campus security authority. At many small schools, it might be the school director. And we want to make sure that we say to students, if something happens to you on our property, we want you to report it to the director's office. Well, the director needs to know what to do with that information. So there's an internal training issue as well. We want to be able to talk to students in an honest way about what our programs are at the school that might help students stay safe. And to do that, we've had to have some honest thought and some contemplative thought about what are the safety issues at our school. I have had many career schools at the FSA training conference come up to me after, and they'll be kind of sheepish about it because they'll be standing around while other people, maybe from the bigger schools, ask their questions, and they'll say, oh, well, my question doesn't sound the same as theirs. And I always say, please don't ever say that to me. Your issues are every bit as important as theirs. I see the consequences when people don't approach it that way, right? Every student, every school is important. And to think about issues just like how are we going to control access to our building? That's what one school owner from a Midwestern state bordering a big city said to me. She said, our biggest safety concern are students who leave our night cosmetology program and have to walk a block down the street to get to where we have them park. And so we talked about access to the building. We talked about the best way to perhaps move students in a group to the parking unit. We talked about possibly contacting the municipality and getting some better street lights put in. I reminded the owner of that school, I said, you're a taxpayer too. Your kids should be able to walk to the parking lot with, in a lit pathway. And that was eventually addressed. So we can talk about whatever we need to in that regard, either during the question and answer period or, again, down the line. But I want you to make sure that you think about these things clearly. We want you to know that there are 4 categories of crime statistics that you have to disclose. The first one are what the law calls criminal offenses. Now, that may sound complicated. What do they mean, criminal offenses? A lot of things are crimes. But under the Clery Act, these are your really serious crimes. If you were to go look online at the statistical survey information that you sent to the department, and of course you can access it on our publicly facing website, you can access every school's data on that website, you would see that criminal offenses are crimes, essentially homicide, these various kinds of homicide crimes, all the way down to the crime of arson. It's not that arson isn't important, but it's a property crime, and we consider that substantially less important than crimes against persons like murders, robberies, aggravated assaults, and of course sex crimes, which are a major focus of the Clery Act. We have hate crime statistics. I don't need to tell all of you, if you watch the news, you've seen that the number of hate crimes are up, and our statistics suggest that it's not just the residential schools where they occur, but in point of fact, I would say somewhere around 15% or 20% of all of the hate crimes that are reported at United States campuses occur at schools that have no housing at all. That wasn't the case even a few years ago, but it is now. There's actually an increase in hate crimes around the United States, and if you think that it can't happen at your relatively small school, that's just not the case. VAWA offenses, the offenses of dating violence, domestic violence, sexual assault, and stalking. It is not uncommon to have dating or domestic violence type situations spread into your campus, even if your school is essentially a version of the old one-room schoolhouse. I have had a number of career schools where the problem is that both members of a household, mom and dad usually, attend the same school. Something happens during the day or something happened at home at night and they bring their problems into your building. You think that dating violence might not occur, but we obviously know that our students are going to get together sometimes, or The people that they are involved with are the ones who are going to come and pick them up at night in the parking lot. And what would otherwise be an uneventful ride home turns into something that comes into your building and becomes a problem. These days, the number of stalking crimes are up, including cyber stalking, which is covered by our law. Well, that can be a problem anywhere. If people are harassing people and it's happening in your space, you're going to need to not only chart it statistically, but take some action intended to stop the behavior. Okay, so we need to think about these things. And then, of course, we're going to have various disciplinary actions that happen within the school. And occasionally we might even have a student arrested at our school for one of these covered areas, which include drug offenses, liquor law offenses, and weapons offenses. I've seen all of those things happen at every kind of school. Obviously, the schools in our space here today are going to be very much reliant on local law enforcement to provide most of the crime statistics. Most of the crimes you're going to have to disclose aren't actually going to happen on your property in a way where the school official receives the report. You might find out about it, but in many cases, the school official knows that there's a problem when the police show up because somebody else called them. Okay, so you need to be ready to receive reports directly, again, through some employee who is designated as a campus security authority, but we also need to reach out to local law enforcement and explain to them that if they haven't already heard about the Clery Act, that we as a school that participates in Title IV need to know the crime statistics for the buildings and properties that we own and control. Please send us this data. If we don't get a response from that law enforcement agency, we're going to actually renew that request. This is why we want to start early. Please do not wait until September, a few days before your annual security report is due, to reach out to local law enforcement. I'd recommend you do it the first time in the spring. By that time, most law enforcement agencies have firmed up their numbers for the prior calendar year. Takes a couple months to do that if you're in the crime business, believe me. So it's not going to help you to ask in January, but if you ask in April, you have a pretty good chance of getting a reasonable response. If you don't get a response that's helpful, I'd renew that request, say, in the summer, perhaps July. And if you don't get a response to those two letters, you always want to do this in writing, email, paper, doesn't matter, but you want to do it in writing. And if you don't get a response, then you could just retain that documentation, and if the department ever asked in a program review or an audit case or whatever it is, you'd be able to say, I made a good faith effort to get data from the local police. They just didn't give me anything. And we consider 2 attempts to be a good faith effort. Now, I mentioned a little bit ago this idea of campus security authorities. This is another one of these lesson learned areas. I'm just going to give you some numbers from cases. In the Penn State case, which became one of the largest Clery Act enforcement cases ever, very large institution with a $4 billion budget annually. On their main campus alone, they had approximately 13,000 employees, and they believed for many years that they had about 300 of these CSAs. Some of them were police officers, some of them were resident assistants, some of them had other job classifications, but they thought they had about 300 of them. By the time we were done with the case, we had identified, and they had participated in that process, 4,024 CSAs. At Michigan State University, the case involving the terrible tragedy of Larry Nassar, which we'll talk about for a minute in a little bit, they thought that they had 47 CSAs at one point. They're going to end up with a couple of thousand by the time the final count is reached. What's my point? At most schools, regardless of its size or orientation, about 20% of employees are going to fall under some part of the definition of campus security authorities. In any instance, you're going to have at least one. So they're usually going to fall under, for schools in our space, that bullet number 3 that says any institutional official with significant responsibilities for student and campus activities. Now, that's generally thought to involve people who work directly with students, mostly on administrative matters. It typically does not involve the faculty, oddly enough. But the school director, if you have somebody who's in charge of enrollment, who could be somebody who contacts the students when they don't show up. At many schools, it could be the registrar, who acts as almost like surrogate parent and counselor, right? So you could imagine that you have many, or at least a large percentage of the small number of overall officials at any one location who might be CSAs. At most schools, the metric is about 20% of employees are CSAs. At some career schools, it's going to be quite higher than that because, of course, very often we're running the whole school with maybe half a dozen people, right? So, again, if you have problems in this area, we can always talk about it specific to your circumstances, but we need to know who our CSAs are. This slide shows the groups of people at all kinds of schools that show up in this area, most of which are simply not going to apply in our space. Now, we will have campus leadership and administrators. Certainly a school director is going to be a CSA. A big part of their job is helping students complete their education. Now, less likely, of course, increasingly prevalent, but still unlikely overall, is that residence life piece. In almost very few instances would we ever have coaches. Most of us are not going to have victim advocates or ombuds people, but sometimes we may have central office staff who at least part of their job is to resolve student complaints, employee issues, and what you may find is that people are actually reporting things that constitute crimes to those officials. So the official who's a CSA for our purposes might not be in our building. They might be at a corporate headquarters or the owner's house. I've seen that happen. We're not going to have many public safety officials, but I will point out if you even have a contract security guard at your school, that counts. Okay. And then we might have some student leaders. We may have people who are parts of student organizations that would fall into this space. And every school, again, is supposed to have a Title IX coordinator. So, you know, we have to comply with Title IX. Someone's going to have to be in charge of it. And that person may receive reports that constitute crimes or incidents under the Clery Act that would have to be part of our statistical disclosures and would be covered by our various policies on things like timely warnings, emergency notifications, evacuation procedures, and sexual assault prevention and response. Right? So we really need to coordinate all this information. We're not going to have a discussion today, but I would like you to consider taking some of this information back to your campus and having a discussion among your colleagues, maybe even at your next meeting. Your school should know how many CSAs it has. If I were to ask any of you individually how many CSAs at your school, it shouldn't take a long time to come up with the number. And then the obvious question is do those people know that they're CSAs? Has the school ever notified them of such? What, if any, training have they received? And how does the school keep track of what it's doing to identify, notify, and train its CSAs? Now, in the very technical sense, somebody may be thinking, if you've looked at some of the Clery material before or you've attended some of our training sessions, you may know that you're not actually required under the law to ever train a CSA. But I would argue that it's practically impossible to comply with the law if those people haven't received some basic training about what the Clery Act is and what it requires. So I would simply ask you to consider these questions amongst yourselves at the school. Now, that is a picture of Jean Clery. Some of you have heard me speak before know that I try to always have a picture of Jean in my presentations. I told her mother many years ago I would do that, but that could be any kid at your school, regardless of their age, from 18 to 80. Or it could be one of your colleagues. There are a lot of bad things that can happen in our environments, just as they can happen in the larger community and around the world. The criminologist in me always reminds people that crime moves, and there's a certain random nature to crime. There's no such thing as a perfectly safe community or a perfectly safe school. So when officials say to me, when something happens and they're ill-prepared, and they say, well, we never thought this could happen here, and I have heard that literally dozens of times in my career, I always say, well, I don't know why you thought that, because that's not the reality of the world. And, you know, I try to be a pretty positive person overall, and I try to take the view that every day above ground is a good day. But we do have to prepare for the bad times. And that means that we have to have a basic understanding of emergency management. Now, again, you might be thinking, look, you know, I'm not the big state university in town. I'm not even the community college. I have a relatively small operation. Why do I need an emergency management plan? What I would encourage you to do is to go online at the website included there and look at our action guide for emergency management at institutions of higher education. It is purposefully written when we put it together several years ago, and we've left it in place because it's still relevant. It was designed to be easy to use. You do not have to be an emergency manager to understand this, but it will take you through the steps from getting organized to implementation and everything in between. And it's going to take you through the basics of preparation through recovery, understanding that every school could have a situation that requires the activation of an emergency management plan. You need at least a bare bones one that will work for you. Now, we talked a few minutes ago about the fact that we have to be able to issue warnings to our students and employees. There's two kinds of warnings under the Clery Act. It's not one, it's two. People continue to confuse this. When we have a Clery reportable crime, and that's one of those serious crimes that I talked about in the earlier graphic, murder, sexual assault, arson, perhaps certain kinds of stalking offenses or hate crimes, or if we had a major drug situation at our school, in whatever form it may take. And whatever that crime is poses some kind of ongoing threat to our Clery geography, which is the school itself and any other property we own or control in our public property border, which in many of our cases is going to be the sidewalk outside our door or perhaps the street that we cross to get to something like a clinic space that we might have in another building, or a retail space that we may have. Some of our cosmetology schools have a beauty supply business that is part of the school, but is perhaps across the street, down the street, a block over. It's still part of our campus, but it's not in the main building that we typically think of as the school. So the school can be more than just the classroom and administrative space. If we have an incident in that space that poses some kind of ongoing threat, we have to be able to warn people about it. If we have any other dangerous condition, so we're not talking about a Clery reportable crime, but we have some other dangerous condition. One could imagine we have schools in this space that have to use dangerous chemicals or dangerous equipment in the training of their students. And all of a sudden there's an issue in part of the building that poses some kind of emergency or other dangerous condition to some group of our students. that poses an immediate threat to their health and safety, we have to be able to warn them too. So we could use the same technology, perhaps a text message, maybe an email would work. At some schools, they have intercoms that accomplish this. You know, at some very large schools, they have siren systems, they have reverse phone calls, closed-circuit TV. I have also been at some smaller career schools where they still have kind of the old-fashioned intercom, and they can simply say there's been an emergency in part of the building and then give directions on what they want people to do next. Not only do you want your policy in your annual security report to say that you can do that, you actually want to be able to do it in an efficient and organized way that will not result in mass chaos for no reason, but will make sure that people have the information they need. I want to give you a few visuals from campus tragedies, quite frankly, because it's important for people to understand what has happened in the past and what we want to avoid in the future. That is the monument at the University of Texas, which is generally thought of as the beginning of the modern era of campus mass shootings, August 1st, 1966. I've always found it interesting the last name on that particular memorial is Baby Boy Wilson. That's because the date on his tombstone is August 1st, 1966. There is no other date. He was shot and died in his mother's belly. You would not think that such an awful thing would happen, but it did on that day at the infamous University of Texas Tower shooting. And from that, we move through some of the major events. Obviously, April 16th, 2007, Sung-Hee Cho, the shooter at Virginia Tech, which for a very short time in American history was the largest mass casualty shooting in our country's history. That did not last very long. It has been surpassed several times since then. I want to take you through a scenario at a smaller school because it's instructive for what I've been talking about. This was in a situation where the financial aid advisor at a small career school in St. Louis was killed when a deranged student, for not any good reason at all, there couldn't be a good enough reason, went up to the 4th floor of the school and shot the financial aid director, and in the process nicked another person with another shot. And as tragic as that was, most of the people who were injured that day in the ensuing chaos had absolutely nothing to do with the wounds inflicted by the assailant with a gun, but rather were hurt in the hallways and on the staircases as students and employees scrambled trying to get to safety, because the school didn't really have a safety plan. People went running everywhere. And something I want you to take away from this as a lesson learned is that what happened to many of those people as they ran out of the building into the streets of downtown St. Louis, you can imagine what happened next. After people were trampled in the stairwells, there were people who got hit by cars as they ran frantically out of the building because nobody had ever really said to them, this is how we're going to evacuate. This is our safety point, our rally point. This is where you're going to check in with a school official to make sure we've accounted for everyone. So you can see that even in the most basic situations, in the most basic of circumstances, we still need to have a plan. This is a small school. This is a career school in a business district. And it happened there. It can happen anywhere. So you've heard the saying, all of you, that every day is the first day of the rest of your life. And that's true, except for the day you die. That is Christopher Harper Mercer, who is the infamous shooter at Umpqua Community College in 2015. This school is a very rural community college. And the thing you need to know about this situation is that picture that's now on your screen, which is a screenshot from CNN, was on the air about 15 minutes after this incident started. 15 minutes. That's the way these things move. Most of these campus shootings are over within 10 to 12 minutes, and the media is on them within 10 to 15 minutes after that. And so we need to have thought about how we're going to respond to these kinds of incidents long before they occur, because these are the images that survive from those cases. When the police officers finally arrived at Umpqua, they did not see any part of the shooting occur, but they did hear the final shot. They rounded the corner from where they heard the report of the rifle and found Christopher Harper Mercer dead of a gunshot wound to the head. After killing 9 of his teachers and classmates, he had turned the gun on himself. Start to finish, 9.5 minutes. That's why we have to have a plan. Even for many small schools, you will find that if you contact your local police and ask them to assist you with putting together a very basic evacuation and emergency plan, they will help you do that if you need assistance, or they will get you in touch with people who can help you. It's definitely worth it in the long run. Now, in addition to that, we need to think about some of the other risks that we might face in the work environment. For some of our schools, we might think about the risk posed by our own employees, that there might be internal threats, that a disgruntled employee might commit some kind of sabotage or commit some kind of violence against members of our campus community. It could range from anything from computer sabotage. Imagine if they destroyed your financial records or your financial aid records, so you want to have some security protections even on your systems. But also if somebody came into work with a weapon, or if somebody was suffering from delusions or some kind of psychotic or suicidal ideation and how that might affect us. We obviously had to be worried about weather, illness outbreaks, and increasingly on college campuses of all sizes, institutions of all kinds, the effects of untreated mental illness, which I'm going to talk to you about in a minute, and then the issues in and around drug and alcohol addiction. Now, to kind of give you an image of this, I want to take you to Purdue University. That is Andrew Bolt. Andrew was an honor roll student, an engineering student at the university, very well liked by his friends and classmates. Those are his brothers. The Bolt boys come from a wonderful family in Wisconsin. Their parents, Jim and Mary, not rich people, but they saved from the time those young men were very, very young. Little kids, in fact, so they'd be able to send them off to university. They were able to send 3 kids away to college. They got 2 back because, unfortunately, Andrew was killed by that man, Cody Cousins. Cody Cousins was a very seriously ill young man. He suffered from drug and alcohol addiction. He also had untreated mental illness. And what happened is that Cody Cousins entered a classroom where a professor and 12 students were studying and killed Andrew Bolt. He shot him 5 times, stabbed him 19. When he was asked about this by the judge, he told the judge, "I killed Andrew Bolt because I wanted to. I'm glad that he's dead." That's how sick Cody Cousins was. The medical examiner said in his autopsy report that it was one of the worst homicides he had ever seen, and he had done a lot of autopsies. Now, here's the concern. Cody Cousins had actually went to the school's counseling and psychological services center at least 17 times. And every time he was basically sent forward to go back to class. What's the point for all of you? If you start to see students who are struggling in some way, they appear to be suffering from mental illness, they appear to be under the influence of drugs and alcohol in a way that seems dangerous, if you have employees who seem to be abusing drugs or alcohol or need other kinds of help, better to interdict, better to offer help, better to ask the question than to have to live with the consequences later, both in terms of human lives and in treasure, because obviously these are situations that result in lawsuits. They are the kind of situations that make people, whether they be students or parents, guidance counselors, pastors, who might be helping students try to figure out what to do with their lives. They say, you know what, you don't need to go to that school. That's the school where that awful thing happened. And fair or unfair, it can have an effect on the bottom line in addition to the damage done to real people. Here's something that I want to share with you because this is brand new. Many of you, if you watch police dramas on television, may have heard of the so-called special relationship rule. Many others have never heard of this, and I don't want to get too deep into it. It's a criminal justice and civil law point because it results in a lot of lawsuits. But generally speaking, the way you say it in policing is that the police have a duty to all, duty to none. That's the phrase, duty to all, duty to none. What does that mean? It means the police owe a duty to everybody, but they don't owe a special duty to anybody. If they did, the police would be in trouble every time a crime occurred. It would stand for the proposition that the police should make a community or a business or a school completely crime-free. That's not the job of the police, right? But in a court case in California called the Regents of the University of California, specifically UCLA versus Rosen, okay? It's become known as the Rosen case. Essentially, the court found that the school owed a student special treatment to keep them safe from crime. This young woman had been attacked by another student who had been known by some to be suffering from mental illness, apparently hearing voices. He thought people were calling him names when they weren't saying anything to him at all. Killed this young woman, okay? And the court found that the college had a duty to keep her safe and that they failed to do so, and therefore she could sue them for money damages, okay, or her estate could. That is a higher standard than has ever been applied in the higher ed space, and as many of you know, legal developments often start in places like California and tend to move east. I would expect that other courts may adopt this approach. We don't know if they will, but they could. We'll see over the next few years, but this really set out a completely different standard, and we need to be aware of it. The idea that the school, and I would imagine it wouldn't matter if it's a little school or a big school because they're saying the right belongs to the student. It doesn't have much to do with the nature of the school, has some specific duty to keep people essentially free of crime. Now, I'm going to beat through several issues with a little bit of speed because I want to get to leave a little bit of time for your questions. But I do need to tell you, obviously on the right, that's Jean Cleary, and by now you've at least heard the name. You now have a face to put with it. The young lady on the left is Laura Dickinson. Laura Dickinson, some 20 years after the death of Jean Cleary, died on the campus of Eastern Michigan University. Their crimes essentially parallel down to the most minute detail. In both instances, the crime started as a burglary, a fairly common offense in America. There's a burglary in the United States about every 22 seconds. and it proceeded to a sexual assault and culminated in the murder of both of these young women. What happened differently in the case of Laura Dickinson is that the school, motivated by many wrong things and ideas, tried to cover it up. And this young woman, who had clearly been the victim of a homicide, her death was reported as an accidental death. They tried to suggest that she died of an asthma attack. The only person who refused to go along with that story was the initial responding officer, a young female officer who told ever higher levels of officials that she would not change her report. It started out with her immediate supervisor and ended with the president of the university. Long story short, she's the only person who's still there. Everyone else at one point or another was removed from service, including the president. So she did the right thing. I always use her story to say to people, will you do the right thing vis-a-vis campus safety and crime prevention when it becomes difficult to do, when it's the harder thing to do? But we need to think about this not merely in terms of a paperwork requirement, but as a requirement that affects real people's lives. And that, again, is true for all of our institutions. Now, some people, again, I think have started to believe that the issue of campus sexual assault is a big school, a residential school problem. And most of the incidents do happen in those places. But I can tell you that the department issued the very first fine for failure to properly report sexual assault statistics against a career school some 15 years ago, when a particular school, for reasons that we don't need to get into now, chose not to disclose 4 sexual assaults that happened on its property. This was a school where men substantially outnumbered women, and a small group of young men decided to commit a string of sexual assaults against classmates. Those young women went to the school officials and said this had happened, and through a combination of circumstances, coincidence, and just bad decision-making, those incidents were never followed up upon, either from a Clery perspective or a Title IX one, and ended up costing the school quite a lot of money in fines and created a bunch of other problems for that institution. So we need to be up on what the requirements are today. And most of those requirements in the Clery space come in the form of the Violence Against Women Reauthorization Act amendments. That law was reauthorized in 2013. We did negotiated rulemaking on it in 2014. The rules went into effect July 1st, 2015. And yet we still see a lot of institutions that have not really done the basics in the VAWA space. And I can tell you that I believe it is going to be an emphasis area for enforcement activity in the next year or two, especially as we go into reauthorization. I know that Congress, because they've already shown some interest, is going to ask the question, you know, what are we doing to enforce VAWA across the spectrum of institutions? And while the department, I think, tried to take an approach that left schools some room to maneuver and to get up to speed, now we'll be moving into a phase where the emphasis will be on compliance and, where necessary, compliance enforcement. So we don't want to lose our focus on training and technical assistance either, but if you're not up to date in this space, it's important that you get there. And if you need help, to ask for it. Okay? So the way to think about what VAWA did is it filled in the space between the existing Clery Act requirements and Title IX. So there's a lot of emphasis on sexual assault prevention, whether it be training, which needs to be available, and more effective measures to see that incidents are properly investigated, either by the Title IX operation at a school, or by the police, or through some other mode that the student victim or the employee victim choose. This law is very much about giving people choices in how they report and what happens next. All right? Again, if you don't have somebody at your school who is the Title IX coordinator, or at your company as the Title IX coordinator for a group of schools, and certainly most of our schools in this space would not have somebody who's just a Title IX coordinator, but perhaps we have an HR professional who has had some training in this area, or somebody has to take it on as an ancillary duty. But if you do that, it's really important that you get some training from a respected vendor in the space to make sure that you understand what it is that you need to be doing in terms of intaking reports, properly looking into those allegations, and then holding fair disciplinary processes. Now, at some big schools, we might have a whole disciplinary board, right? We hold hearings that start to look like trials. We're not going to have that in our space. It may be down to one official who's going to listen to one side, listen to the other, and issue a common sense finding. And then we're going to look at whatever we've said in our policies and procedures about punishment. Perhaps somebody needs to be suspended for a period of time. They have to take training. They need to take any number of other steps up to and including, expulsion or termination as an employee, right? But we need to make sure that we have coverage in these areas, and you want to make sure that the person who is designated to conduct any kind of a disciplinary hearing has been trained in the requirements of the Clery Act. Now, there's different ways to meet that requirement. There are vendors who provide training. There are nonprofit entities that provide training. There's training you can buy off the shelf. There's online training that you can pay for on an as-needed, person-to-person basis. So there's different ways to meet this at different levels of need. But we want to make sure that students have an idea of how they are to file complaints. We want to make sure that they know what the possible outcomes of filing those complaints are. That people receive notice about meetings and hearings. We want to make sure that the process is fair and timely. If we have somebody who makes a complaint on, let's just say, May 1st, if we don't start to investigate until July 1st, we better have a darn good reason. If we don't reach a conclusion in the case within a reasonable amount of time, say 30, 60 days, or something along those lines that we've said in our policy, we better have a really good answer, because people file complaints and the government may inquire, why did it take so long? You have to let students and employees who have been victims and the person who was accused to have an advisor. This could be an employee. It could be their attorney. It could be their mom or dad. It could be their best friend. But you have to let them pick the person. Okay, there's very few limitations on who they can pick, and we can talk about it at some point if we need to talk offline about possible limitations. But in general, we really need to let them have the advisor that they choose, not that we choose for them. We want to make sure that those hearing processes are fair, that both sides get to speak and present evidence if they have it. And we want to make sure that people are learning about the outcomes of these hearings at about the same time. What we cannot do anymore, and what we cannot countenance, is, say, the school officials going to the accused party and say, just so you know, we're going to find you responsible for this violation. The one way you might be able to avoid punishment from us is if you just leave, right, and go to some other school, because under our policy we only have jurisdiction over you if you're still in the role. And then you wait till he goes, and then you tell the person who accused that individual and say, oh, yeah, we were about to find him responsible, him or her, but we've decided that we don't need to do that because what you don't know is he withdrew from school a week ago, right? We need simultaneous notification. Now, I just want to remind you about a couple of Title IX issues because, again, we know we're going to get new Title IX regs. We believe they're going to come out this month, in fact. That's a little bit of news, but I've been told that they are going to hit this month. Then we'll need to take some time to make sense out of it. But Title IX, in its essence, in its statutory essence, will not change, and just stands for the proposition that people should be free of sexual discrimination when they're engaged in an educational program at any school that receives money from the department. Easy concept, common sense rule, but of course it can get a little complicated in its application, right? So the first and best thing you can do to help your school is to have a Title IX coordinator. Every school is to have one, but many schools don't. Or they have made it such an ancillary duty, they've tacked it onto somebody who already has 10 important things to do. That opens up the school to a lot of exposure. You also want to make it easy for students and employees to report. You do not want students, and people again might think this is a big school problem, and sometimes it is. You'll have a campus of 50,000 people, and students will say to us all the time, well, we had no idea where we're supposed to report these claims. But I have found very small schools, at schools that have fewer than 100 students, and nobody in the printed materials or at orientation or anywhere else has ever said to those students, this is where you come to report concerns about, say, sexual discrimination, which includes sexual harassment and sexual violence under Title IX. You want to make sure that people know what the standard is at your school. Are we going to use what is typically called preponderance of the evidence? Under some changes that Secretary DeVos made a year or two ago, a school could have a different standard of evidence. They could say we're going to use the clear and convincing standard, which is a much higher threshold that people would have to cross. Preponderance of the evidence basically means if the evidence, 50.1% of it, tilts toward one direction, that person's claim is vindicated, whether that means they'll be held responsible or not responsible, right? At a school that has clear and convincing, that's a much higher standard, harder to put a percentage on it. Some people will say, you know, it's about 75%. Others will say, I'm not going to get into trying to figure out what the standard for clear and convincing is, but it really means that there's strong evidence. And of course, in many campus sexual harassment or sexual violence cases, there's not going to be evidence of the type of, say, physical signs. It's not your classic rapist who's literally jumping out of a tree or jumping from behind a fence. It might be somebody who has known someone for a long period of time and has kind of taken advantage of their acquaintance or their friend. Okay? So we want to make sure that we have all of this written down so that nobody can ever say, I didn't know what the procedure was. It's extremely important. This graphic kind of gives you the life cycle of a Title IX case, okay? This is, if you think of it this way, right, and you can kind of start at any point and go around the circle, but what you want to make sure is that your policies and your procedures kind of cover these areas. What rights and options does a victim have? How are they going to report? Are we going to take any steps to try to prevent reoccurrence of whatever it is that happened? Maybe we're going to take the two persons who have been involved in a case and put them in separate sections. Maybe we're going to have somebody attend at night instead of during the day because we just want to keep them apart. We might issue a no contact order. How are we going to go about investigating these allegations? And what are we going to do in the larger sense to educate our student body, our campus community, about what our expectations are for people's behavior and do what we can to prevent similar offenses from occurring? Okay? Again, what I want to tell you is about the intersection of Clery and Title IX is that Clery is primarily about crime, and Title IX is primarily about civil rights. It's about the person's right, the individual's right to be free from sexual discrimination, which again includes sexual harassment and sexual violence. Clery is about their right to be informed about campus safety and crime prevention, and now under the VAWA provisions, to also have some additional rights especially in what you might think of as the sexual assault prevention and response area. So it kind of bolsters some of what was already happening under Title IX. Here's an important point that comes up all the time that people want reassurance of. If you have put the basics of Title IX in place and the basics of Clery, your compliance with one of those requirements will never cause you to commit a violation of the other. These laws do not really conflict, nor do they contradict each other. You can go some places, people will have whole sessions at conferences about the conflicts and contradictions between the Clery Act and Title IX, except they can't actually list any. There aren't any. Certainly not under the current rules, and we'll do what we can to make sure that when the new rules come out that we reconcile anything that might be a problem there. Okay? But just remember that. You're not going to break one rule by following the other. Now, I just want to wind down on some things here. That is a 1-mile circle around the police station in my, thankfully, rather nice hometown. And those 12 little dots are the serious level 1 sex offenders. They live right around the police station. Okay? What's my point? About 1% of the global population are pedophiles. 1% of the world's population. About 7 billion people on the planet. All right? Of that 1%, only about 20% will ever offend. Most pedophiles don't actually ever hurt any child. All right. Now, you might think I don't have a lot of children at my school, but you may have kids in and out of there from time to time for various reasons. You may have students that are under the age of 18. There are all sorts of scenarios that could develop. People have child care issues. They sometimes bring their kids to school. I've seen all variations. I've seen weekend programs where kids are on the property. Well, if 20% of the 1% actually are pedophiles that will offend, that means at any one time on the planet, we have about 14 million people who sexually abuse at least one child. That means, as a matter of math, that some of those people are going to show up on campuses, and they have. But not all of them are going to show up at big schools. They can show up anywhere, all right? Because I'll tell you what you don't want at your school. You do not want one of those. Jerry Sandusky was able to terrorize children with impunity for decades, and he did much of it because of his role at Penn State University and through the charity that he set up that became prominent because of his affiliation with the university and the fame he kind of garnered as a result of his football coaching career. Stephen Jensen, that man was allowed to work in emergency pediatrics at a university hospital for years in spite of the fact that people knew he was addicted to child pornography. He was so addicted to it that he brought it to work with him on flash drives. And nobody ever did anything about it until the Sandusky case put the issue on the map for that university. And the college president, to her credit, said, if anybody knows of any similar situations, I want to know about them now. If you come forward, you won't be fired. If you don't come forward, you will. And then there's Nassar. I spent a lot of time working on this case, and I can tell you that you could end up with somebody like him at any kind of school. It just so happened he was at a really big one, and the consequences were terrible. That's a picture of the mom's section, parent section, at the part of the trial where the victim impact statements were read. 332 victims in that batch. I believe 179 of them gave victim impact statements. It took several days to do, and the judge allowed it to continue until every person who wanted to had spoken. There are additional victims being identified all the time. I believe now the number is over 500 in total. Now, again, you don't want there to be one at your school. And we need to take steps to make sure that that doesn't happen. Along those lines, I want to encourage you with every kind of complaint that you might receive, resolve them quickly and completely if at all possible. I want to encourage you to come up with ways to keep people informed and to stay up to date about things that might affect their safety and about what's happening at the school in general. And where possible, try to form strong partnerships with community leaders and your local law enforcement. That's good for your school in every aspect. That's not just about campus safety. That's about good and effective business. So I want to encourage you to do that as well. I want you to think about administrative capability in the Title IV context. Okay? We talk about administrative capability all the time when we talk about financial aid, not as much when we talk about campus safety, but the rules apply. If you look at some of those program review reports I mentioned, you will actually see that we have made impaired administrative capability findings at several schools because of Clery violations and some violations of the Drug-Free Schools and Communities Act. Now, what I'm going to do is stop here and suggest to you that when you have time, this is not the sort of slide that actually helps for me to talk about. What will make this slide useful is if you take it, if you're going to have access to them, I think Tommy will probably arrange for that, or we will make sure that you have access to it, or you could even take a picture of it. But you need to be able to take a look at some of your policies and procedures, your disclosures that you've provided to students, either through your ASR, your handbooks, your catalogs, however you've done it, and make sure that you can be satisfied with your answer in each of these 5 areas as a test of your administrative capability. And with that, I'm going to stop and see if we can at least get a couple of questions before we have to end.
Jim, thank you so much. First of all, just so everybody is aware, the comprehensive slide presentation that Jim was just so gracious to share with us will be available for all 96 to 100 registrants and participants on today's call. As I said at the announcement at the beginning, as we always do with CSPEN webinars, and with Jim's permission, both the audio as well as the slides will be available for your review at a later point in time with access given to you by CSPEN. Jim, as it stands right now, I'm going to say that I haven't seen a question yet, but the lines are open, if you will, to type out any questions that any of the participants may have. I am going to take the role of the chair and at least ask one question. You seem to intimate that we are looking for the likelihood of the final rule coming out. You said this month. That doesn't leave a lot of time.
Right.
Especially when we consider that next week is Thanksgiving week. But is there anything that you can tell us that about what you're hearing there, or any additional information you can share in terms of maybe any early implementation requirements? Is that being considered, or are we looking at obviously a lot to digest, all of which will not go into effect until July 1 of 2021, correct?
So what I'm hearing, and all of this is because this has been a very close hold package. We have been consulted in terms of intersection with Clery, but it's, as many of you know, when we do Title IV rulemaking, we use negotiated rulemaking, and it's a very open process. I'm not criticizing the process being used here. It's a completely legal one, but it's not quite as open as the process that FSA has to use. What I have heard is that there will not be an early implementation. They understand that institutions are going to need a period of time to synthesize these rules and implement them on campuses. I also know there will be, I know that group over there is committed to providing information sessions and other learning tools to help schools get up to speed. And what I will say to the CSPEN group is that I will certainly work with Tom to arrange another opportunity for us to break it down and kind of help you normalize it with Clery as well, because what we don't want you to do is kind of reinvent the wheel. I think in most cases you'll be able to take what's coming new from OCR and fit most of it into the structure that you should already have or that you're going to build going forward. But I believe we're going to actually be able to do this without a lot of new problems.
That's excellent. Jim, well, obviously, so I will put in a plug for you and for the department at all. Obviously, if it does come out between now and the end of the month, certainly we will be looking, and you will have likely a very widely attended event as part of the FSA conference the week of December 2nd through the 6th, because I think everybody is going to be, especially given all of what you've just discussed, interested in what the outcome of those 150,000 plus responses and certainly the changes that were being considered as part of the NPRM. So thank you for giving us the heads up a little bit ahead of time, and I'm sure that I, along with many others, will be sharing time with you in Reno in just a couple of weeks. The last question. Go ahead.
No, I was just going to say thank you for mentioning the conference and of course the Clery session that we'll have there. We'll also have a desk in the resource room that'll have Clery folks there. I'll be one of them, but I'll have one of my colleagues there as well. And you can talk about those specific questions that you might have that you might not want to do on an open webinar. And if the Title IX rules do in fact drop the week before the conference, which I have been expecting anyway, long before I heard that that's what's going to likely happen, I will try to get some advance information and be able to offer some kind of wisdom in addition to the information we've already planned to share at the conference, so that people can start to use these rules and make sure that there's not unnecessary violations or unnecessary complications.
You highlighted a few takeaways. I'm definitely going to put on the CSPEN calendar to remind individuals in April and July for asking for their campus for the crime statistics of the local area. You certainly have highlighted the new circumstances with regard to litigation and interpretations out of California that we're going to share with individuals going forward from this presentation. You know, my last question, it's the one I always ask you. What should we be asking as a question that we're too naive or too scared to ask you?
I think it has a lot to do for schools in our space on this call today about building security and the ability to issue those required warnings that we talked about. When I see problems at a lot of the schools in our space, it is in and around basic building security, people getting in the school who we might not want there, causing problems that we would rather not have to deal with, and difficulties in figuring out how to warn, because again, we're probably not going to have a sophisticated text messaging system, and we're not going to have email accounts for everybody. So how do we modulate that in a way that makes sense and isn't going to cost us too much money? So those are things that we might want to look at down the line as additional topics to cover.
And I will look to work with you to do that as we move forward. I'm going to hold you to, and we've got it on audio, the opportunity to do a follow-up webinar in the future. I hope you're smiling. On behalf of CSPEN, on behalf of the individuals, there aren't any questions that I see, but there are several statements of appreciation to you, Jim, in particular, and expressing how informative and helpful and great with exclamation points and thank yous with exclamation points this presentation was. So we do thank you. I do thank you on behalf of those that have participated, and I'm sure the word will, as it always does within this community, the word will get out a little bit, and others will have the opportunity to review it and get the information as well. I look forward to sharing time with you and breaking bread with you in a couple of weeks. This will conclude today's webinar. I do remind everybody on this call that in December, we will be announcing upcoming webinars. One will be with Dr. Wallace Pond, who has done a great deal of research and provided information on changes within the higher education community and what the future may look like, given what his data suggests. It was a presentation that he provided at our annual conference back in August, and we'll be providing yet again for those who weren't able to attend and updated versions of it in December. So with that, and with being a few minutes over, but I think for good reason, I want to conclude with once again saying, Jim, thank you very, very much. Thank you for everybody that attended, and have a great Thanksgiving. Bye now.
Bye-bye.